Before we start, I'd like to begin by acknowledging the people of the Kulin Nations, on whose land our major campuses operate, and also the Wurundjeri people, from whose land I'm broadcasting from today. I pay my respects to their elders, past and present, and I pay my respects to traditional owners of the land from wherever you may be joining us. So yes, here we go. Welcome then. Welcome to this event. It's a event that's hosted jointly by the International Trade and International Commercial Law Research Group and the Labour Equality and Human Rights Research Groups in the Department of Business Law and Taxation. I'm Nicola Carver. I'm one of the co-directors of the International Trade and Commercial Law Research Group. I think my colleague Ben Hayward might be out there somewhere. He's my co-director. And also my colleague Dominique Allen, who's the director of Labour Equality and Human Rights Research Group, and who's co-convening this session with me today. We're here, of course, to hear from Jill Murray, who I'm delighted to say is an adjunct associate professor with the Department of Business Law and Taxation. Jill holds degrees in law and arts and industrial relations from the University of Melbourne and Oxford, and she's published widely on international and Australian employment law, as well as contributing to policy development in labour regulations, both here and internationally. But Jill, of course, is here today to talk to us about the labour dispute between the European Union and Korea that was conducted under provisions from their trade agreement, under the Trade and Sustainable Development chapter in their trade agreement. And that agreement has been in place since 2011. In fact, states led by the United States and the European Union have been incorporating labour commitments into their trade agreements since around the mid-1990s. But these provisions remain quite uncertain and untested. And this dispute that Jill's going to talk about today between Korea and the European Union is only the second time that any formal action has been pursued under labour commitments in a trade agreement. And of course, Jill Murray was appointed as the chairperson of the panel of experts that was established to consider the complaints by the European Union. So I think I'll finish my introduction there and cross over to Jill. Jill, hello and welcome.
Hello.
There you are. Thank you so much for joining us today, agreeing to come and talk to us today about the dispute and your role in the dispute. Perhaps do you want to start by telling us a little bit about the dispute and how you came to be involved in the panel?
Okay, so there are two separate questions, how I came to be involved in the panel. I'll start with that one. First of all, hello everyone. It's lovely to see you today. I did my doctorate on international labour law at Oxford University, and since that time I've published quite widely in the area, and I've also undertaken research work for governments in Australia and overseas and for the International Labour Organization. So I suppose my name was known in that field. Under the EU-Korea Free Trade Agreement, there's a requirement that a list of experts' names be gathered together. So if there's a dispute, someone can be selected from that list to chair the dispute panel. And quite a number of years ago, I was asked, would I agree to my name going on the list? And never thinking the day would come, I said yes. And then I heard in May last year that the person who'd originally been appointed the chair of the panel had unfortunately died, become ill and died. And so I was invited by the two other panel members to become the chair of the panel, and I did, and that's how I started the role. So it's, I am, I suppose, in that role as an international expert in labour matters. I should say my comments today are on, I'm speaking on a personal basis, not as a chair of a panel. Our report was a unanimous decision of the three of us, It's 30,000 words long, so it's quite difficult to accurately summarise it in a way that's going to be useful for you today. So please take these as personal comments in that respect. So Nicola, will I say a bit about the dispute itself?
Yes, please, yeah.
Okay, I'm just going to share my screen because I think it's easier for you to see some of this written down. So under the free trade agreement, there's a process of consultation at the government to government level. So for a number of years, in fact, the European Union had been raising concerns with Korea in relation to its Trade Union Act, which is the abbreviation of which is the TULRA. So there were a number of concerns about the TULRA, and the governments were discussing them. And ultimately, that led to the European Union deciding that the discussions had not led far enough in a fruitful direction, and so they requested that a panel be formed. And the EU panel request forms the jurisdiction for the panel. So what they asked us to look at is what we look at. And here's just a summary of what they were concerned about. And essentially, there were two parts to their complaint. The first part related to the TULRA itself and a number of aspects in that legislation. The first one related to the definition of worker in the Korean Act, which excluded the self-employed, the dismissed, and unemployed persons. The second provision of concern was that a union could be decertified, that is deregistered, if it permitted those classes of people to remain members. So if you were dismissed from your job but you were still in the union, then the whole union could be decertified. And unions which had as part of their rules the possibility that the unemployed, dismissed, or self-employed could not gain certification. The third issue was a requirement that union officials must come from amongst the membership of the union, and that I can say a bit more about that later. And the final concern of the European Union related to the process of certification itself, which they said the European Union alleged amounted to a discretionary process where the state played an overly invasive role in deciding which unions could be certified. And by certification, I mean they're given the legal protections of unions under the Act to function and take action and so on. So that was the first part of the dispute. And the second part related to Korea's efforts to ratify the core conventions of the International Labour Organization. And the European Union argued that essentially Korea was dragging its feet on the matter and not meeting its requirements to progress ratification of the standards. So they were the matters that were in dispute. And I'll just quickly, spoiler alert, here's the panel's decision. So in relation to the first three matters under the TULRA, the panel found that Korea was in breach of binding obligations that it had under the free trade agreement in respect to those first three matters listed above. That is the definition of worker, whether or not an organisation could remain certified if it permitted non-workers as members, and the question of the election of the union officials. We found that these were not consistent with the free trade agreement. In relation to the fourth point, we agreed with Korea that the union certification process was consistent with its obligations under the free trade agreement. And we also agreed with Korea in relation to the dispute about the International Labour Conventions that Korea was making the appropriate efforts in that direction. So that's the outcome. I thought I'll give you that first.
Yeah, that's helpful. Thank you. So you mentioned then with that fourth complaint that there were specific commitments to ratify and implement certain ILO conventions. What were the other commitments in the agreement?
Well, let me show you, because actually we found that there's no requirement in the agreement that they do ratify the ILO conventions. So that was why we found in their favour there. So the main provision that we're dealing with is this one, Article 13.4.3 of the Free Trade Agreement, which states, as you see, the parties, in accordance with the obligations deriving from membership of the ILO and the ILO Declaration on Fundamental Principles and Rights at Work, commit to respecting, promoting and realising the principles concerning the fundamental rights, namely, and then 1A, freedom of association. So the whole dispute was really within that scope. The matters raised by the European Union went to freedom of association in respect to the TULRA element of the dispute. So what the panel had to determine is what is the meaning of that paragraph. And I should show you this as well. So the scope clause of the Free Trade Agreement states, except as otherwise provided in this chapter applies to measures adopted or maintained by the parties affecting trade-related aspects of labour. So in the context of the opening provisions of the chapter. So the key question was that Korea raised as a jurisdictional matter that the EU panel request was flawed because it did not identify trade-related aspects of labour. As you saw from the panel request, it's general, isn't it? It goes to the general definition of worker in the TULRA without identifying a trade-related aspect of labour per se, okay? And so the initial task of the panel was to determine the jurisdictional objection of Korea.
So what do you mean by a trade-related aspect of?
Well, indeed. So that is a very big question, and if I may, I will come back to it in a minute, because
okay. Yeah, all right.
So we decided that our obligations as an independent panel to interpret the Free Trade Agreement were those of the Vienna Convention on the Law of Treaties. So we interpret the text of the convention in good faith, in accordance with the ordinary meaning of the text, in its context and in light of the object and purpose of the Free Trade Agreement. And looking at Article 13.4.3, we decided that the intrinsic meaning of that first paragraph is not limited to trade-related aspects of labour. So the reference to fundamental rights in Article 13.4.3, we felt was a direct indication that the parties had not so limited the words, and that was obvious on the face of the text. The panel noted that it is not possible to ratify ILO conventions with a reservation. So there's no way in which a party could meet the obligations of this section of the Free Trade Agreement only in relation to trade-related aspects of labour. We noticed that the language of the provision talks about the elimination of all forms of forced labour, for example. So there's nothing there that would suggest that it's directed only in that way. So we felt the meaning of the provision in front of us was clear, and it fell within the except as otherwise provided element of the scope. Then we looked at the context, and in the preceding paragraph, there's a reference to the parties cooperating on labour matters, which specifies that that cooperation is limited to trade-related matters. So in the very previous paragraph, there's a limitation to trade-related. So we felt that if that had been the intention of the parties, the similar limitation would have been expressed in 13.4.3. And then we had a look at the broader context and the object and purpose of the chapter and of the free trade agreement itself. And that required the panel to have regard to the notion of sustainable development and what that meant and its relevance for understanding the paragraph we were dealing with. And we felt that the language of sustainable development adopted in the free trade agreement affirmed our view of the paragraph. So there was no conflict between our interpretation of the paragraph and our understanding of the sustainable development concepts, which in the preamble to the free trade agreement are referred to in terms of full employment and decent work for all. So the sustainable development vision, if I can call it that, or the values embedded in that notion seemed to us, and this is a gross paraphrase, but it seemed to us to involve a commitment to trade evolving in a way that protected and promoted fundamental rights, not only in relation to trade-related aspects, but generally. So these were elements that we felt bolstered what we were saying about this paragraph. We also noted the reference to the Universal Declaration of Human Rights in the preamble. And of course, as you know, it protects freedom of association for, quote, everyone. So if you're going to use these elements in the framing of the free trade agreement, we felt that this provision should be read not limited to trade-related aspects of labour. Having said that, the panel then went on to state that we believe that these fundamental labour rights are intrinsically related to trade.
Right.
Okay, so we didn't say that there was no relation to trade, but we said that the scope was not limited in that way.
So how significant or valuable do you think it was that the EU has tied up its approach to trade and labour by putting the ILO or conventions, especially those that deal with fundamental labour rights, sort of at the centre of their commitments?
It's very significant, I think, but can I point out to you some further complexity here?
Yeah.
It looks quite an innocuous sort of statement, doesn't it? But it's actually very complex. So in relation to Part A of the EU dispute about the tool provisions, we're trying to apply this phrase, okay? So in accordance with the obligations deriving from membership of the ILO, so the first thing we then had to do after we resolved the jurisdiction issue is what is meant by the obligations deriving from the membership of the ILO. Now, within the ILO, it's often stated that member states of the ILO give up a little bit of national sovereignty when they join the ILO, and they are bound by to adhere to, at the very least, the principles of freedom of association, and probably all these principles in A, B, C, and D. But freedom of association is the most evolved of the ILO core standards. So the ILO believes and states members must obey freedom of association principles, whether or not they've ratified the ILO convention. So the conventions on freedom of association. So that makes this a unique circumstance in international law. Without the ratification, they have that obligation. Now, the panel had to decide what is actually meant in terms of legal obligations arising from the free trade agreement, because that assertion that membership of the ILO brings with it that binding obligation has never been tested in the International Court of Justice. And of course, it's not up to the panel to determine that matter. We're not able to do that. So that was a very important issue for us to decide. And what we decided was that the free trade agreement itself creates a new obligation on the parties. So we are not judging the ILO and its regime. What we're saying is that in making the agreement, the parties have taken on board a new commitment, which is they commit to respecting, promoting and realising the principles concerning the fundamental rights, and that includes freedom of association. So why I went through all of that about the ILO is because the next thing the panel had to decide is the principles concerning the fundamental rights. What are they? So Korea had argued that if we got as far as overcoming their jurisdictional argument, overcoming the fact that the ILO constitution obligation is not binding, and overcoming the fact that the Declaration on Fundamental Principles and Rights at Work is explicitly non-binding. At the time it was made, it was stated that states would not be taking on any additional obligation. So Korea said, if you get over all those hurdles, then we say there are no specific enough principles concerning the fundamental rights for you to determine the dispute. So then we had to work out, well, what are the principles concerning the fundamental rights? And the panel felt that the ILO has sufficiently evolved its jurisprudence, if I can call it that, on freedom of association for the panel to rely on the principles thereby developed. So the Committee on Freedom of Association of the ILO publishes a digest of decisions which give a lot of granular detail about what is meant by freedom of association in the ILO's view. And we decided that it would be appropriate for the panel to have regard to those principles in determining the matters before us. And that sounds very vague, doesn't it? But it was a pretty important step in our logic because we felt that when you look at the United Nations human rights regime, the European human rights regime, the constitutional courts in countries around the world like Canada and South Africa, they have also done that. They have relied on the evolving principles of the Committee on Freedom of Association to fill in what is meant by freedom of association. So they were the logical steps we went through. So although the ILO Constitution's legal status is unclear, and although the ILO declaration is not binding, we found that new obligations were taken on board and that the principles were those explicated by the ILO. Mm. So that was how we dealt with these matters. So when you look at what the ILO says freedom of association means, it's everyone without distinction whatsoever has the right of freedom of association. So we found that this provision was not consistent. The ILO Committee on Freedom of Association in relation to 2 is most concerned that a situation could arise that you could sack union officials and then the whole union might be deregistered. And the panel received amicus curiae briefs from civil society who told us that that had in fact happened to one of the Korean unions with 60,000 members, that some of the officials were dismissed and then the union was deregistered on that basis. And the ILO says that is not consistent with freedom of association. So that was the panel's finding. And the ILO says that unions should be free to elect their officials, as they see fit, and that the state should not limit. And so that was the basis of our decision there. And Nicola, can I just say something at this point about 4, the discretionary certification process? Here, the ILO is also very clear that the freedom of association requires that the state should not overly control which unions become certified and that it shouldn't exercise a discretion it's okay for the state to say, well, we want to know what the address of the union is, and we want to know the names of the officials. It can set requirements, but this shouldn't be a matter of the state picking and choosing which union comes into existence. But the panel was informed by Korea that the Korean Constitutional Court has already considered this very matter, because freedom of association is a constitutional right in the Korean constitution. And the question of the certification process had been dealt with by the Korean court, and it had held on nearly the same point that we were dealing with, that this was not an illegitimate discretionary process. So the panel deferred to the decision of the Constitutional Court. And I should also say that there was conflicting evidence on this point, and people might be interested to talk about this later, because the taking of evidence by panels in these trade disputes seems to be a rather problematic matter. So we'd had the written submissions from the civil society, and then material from the Korean government, but they were in conflict, in some cases in direct conflict. So in light of the really paucity of evidence there, and also the Korean Constitutional Court's decision, we did not accept the European Union's arguments there. So that was the first part of the dispute, and let me just quickly take you to the second. So here, the provision that we were dealing with goes on to talk about the ratification of ILO conventions. And in particular, it says the parties will make continued and sustained efforts towards ratifying the fundamental ILO conventions. So just think to yourselves, if I was having to deal with that, what does that actually mean? The parties will make continued and sustained efforts towards ratifying. The panel found that this is not a requirement to ratify. Obviously, it is not. And then the question of were the efforts continued and sustained was incredibly difficult to judge. And we were told by the Korean government that there were bills before the legislature in Korea to bring about ratification of the core conventions, 87 and 98 on freedom of association, and Convention 29 on forced labour. And that over the years, various steps had in fact been taken. And so the panel found that on that matter, we found for Korea that their efforts, while they were not, well, they may have been deficient in some respects, they didn't fall below the standards set by the free trade agreement.
I think the phrase used in the report is less than optimal, isn't it?
Yes.
Yeah. Less than optimal, but still not below the standard requirement.
And I must say that since the panel's decision, the Korea has ratified Conventions 87, 98 and 29, which is a great achievement for Korea, a great step forward in a way, and also for the ILO, which has been engaged with Korea for many years on that matter.
Well, thank you for that overview of the issues and the decision. We've still got quite a bit of time, which is good, because I wanted to ask you a little bit about this dispute, which is sort of based on the European Union's approach to incorporating labour commitments into trade agreements, and contrast that with the previous dispute, which arose under the United States agreement in South America against Guatemala. So looking through the report, I can see that Korea sought to draw on that earlier decision in its claims at various points. And I think the two cases are sort of indicative of the two different approaches of the US and the type of provisions that the US incorporates into its trade agreements, which tend to be more sanction-based, and may still be best endeavours provisions, but with some legal commitments as well. And then the EU approach, which puts the ILO at the, or some ILO agreements at the centre. So I wondered if we could talk a little bit about that case. So maybe we could start with what the Guatemala-US dispute was about and the decision there.
Yes, so the US alleged that Guatemala was not enforcing its domestic labour laws. And that was a bit of an understatement because there was quite kind of severe anti-union action occurring in Guatemala. And I think some on the Labor side have expressed concern at that decision because it was so obvious that there were things being done not consistent with the Guatemalan Labor regime. And yet it was not possible to meet the hurdle in the free trade agreement to sanction Guatemala in any way. However, I do caution, let me just share the screen again, sorry, that the dispute was about a completely different thing to the Korean dispute. So it's always very important to have a look at what things are actually about. So here's the provision in the Central American Free Trade Agreement and Dominican Republic. A party shall not fail to effectively enforce its environmental and labour laws through a sustained or recurring course of action or inaction in a manner affecting trade or investment between the parties. So there, the provision in the dispute directly required the panel to find that something had occurred or not occurred in a manner affecting trade. So that whole decision is a very lengthy and learned kind of attempt to do that. And the panel reached a very kind of tight definition of what that means. And essentially what they said would be necessary to meet this standard, a legal standard in the CAFTA area, was that at the level of the business or the enterprise complained of, you would need to identify that they engage with trade directly themselves, or they competed against imports coming from another CAFTA party, and that the failure or the action or inaction identified actually led to an economic consequence for that firm, and that economic consequence had to be amounting to a competitive disadvantage for the firm. So Lance Comper and other commentators, I guess you'd say from the Labor side, have said that is an impossible bar to meet, because you would need to know you would need to have access to the books of the enterprise, really, to gain the kind of detailed financial information necessary to make an argument under that case. And I've read other academic commentators say that essentially nullifies that provision, because it would be so hard to meet that bar. But I do note that, as I think I've shown you already, the provisions that we were looking at are quite different, aren't they? So we were not looking at a provision which said that we had to identify a manner affecting trade. So Korea in its submissions not only used this decision and said we should follow it, but that's sort of how, given that the provisions we were looking at were different. But Korea often, several times, referred to a kind of general overarching requirement that when interpreting a free trade agreement, you have to have regard to this manner affecting trade. But we were bound by the texts that we were faced with, which set a very different standard. So yeah, that decision, despite finding that Guatemala did not enforce its labour laws, it did not meet the standard required by the free trade agreement. And so there was no finding against Guatemala in that case.
So perhaps you mentioned a few commentators who responded to the US Guatemala decision as interpreting the provision so narrowly as to render it dysfunctional. But more than one commentator has suggested that the decision of the expert panel in the EU and Korea case could be criticised as too pro-Labor. So I just wondered if you'd like an opportunity to respond to that or have any comments in relation to that.
It's interesting that there's a criticism from a Labor side about the second part of our decision in relation to the continued and sustained effort to ratify. So it's the EU expresses disappointment in our decision to that extent. Look, the panel was comprised of eminent experts chosen by Korea and the EU and me, and we interpreted the treaty in a very orthodox manner. So it's certainly not with a view to being pro or anti-Labor or pro or anti-Korea or the EU. I think I've shown in my earlier part of the talk that there's nothing, really, there was no other path we could take in the interpretation that we made. I think a bigger, more interesting question is, given that that was our decision, and I think it's defensible, that whether there will be a change in the drafting of these agreements going forward. So we did rely on, as we're required to do, the context and the object and purpose of the free trade agreement in reaching our interpretation. And I wonder if in future parties which do not want to be bound by core Labor standards may choose to frame their agreements differently. Because if you're going to commit to doing something, then you can't be surprised that a panel finds that you have committed to do it. So there may be, I don't know, there may be some shift in future language used in these agreements. The other thing is the European Union itself is reviewing its use of sustainable development as a framing device in its free trade agreements. I'm not sure what that's about, but that's occurring right now. So we'll see what emerges from that. In relation to America and its agreements, I think you can be overly black and white about the difference there, because Obama era agreements actually are very similar to the European Union. So there's not a kind of a total American picture. It'd be interesting to see what President Biden does during his term.
Yeah, certainly one of the difficulties with understanding what the obligations are in trade agreements is the fact that the variations in the provisions from agreement to agreement seem to constantly change. There's not a lot of consistency as countries, even like the US, demonstrate a lot of plurality. Well, I think I'm mindful of the time, so I think maybe we'll stop with the questions that we collated we've put to you. And thank you so much for your insights into those. And perhaps now I'll hand over to my colleague Dominique, who will moderate some discussion. So we'll open it up to questions from our guests. Dominique, are you there?
Yes, I'm here. Yes, thank you both for that really interesting discussion. And yeah, we've got plenty of time for questions. So we'll either get people to raise your hands if you want to put something in the chat to indicate you've got a question. There's time for that discussion. So I'm going to start with Carolyn, because I see she's got her hand up if you'd like to ask a question.
Thanks, Dominique. Thanks so much, Jill. That was just fascinating. And particularly in relation to how clear it is in understanding how you've gone about making that decision. I just wondered if you'd be willing to say anything about the process of coming to consensus with your panel members. you mentioned that, you know, in the end, it was pretty clear what the decision would be. But given the length of your decision, are you willing to say anything about the deliberations about how to word your findings?
Well, I'd love to talk about this. The circumstances were very odd. As I said, the panel had been working away for quite a period of time when the former chairperson passed away. But they were still at the preliminary stages of determining the process, because each panel decides its own procedures. So they were drafting rules, and the panel was supposed to conduct a hearing in Geneva at the World Trade Organization, and the civil society were gearing up to attend that hearing. But COVID intervened. So the whole thing was conducted online. I was sitting in my lounge room, and because we were in different time zones, most of our work was done at night. And in the end, we had a hearing online with Geneva and Seoul and Brussels, you know, at 6, 7, 8, 9, 10 at night. So it was a very, very unusual situation. I didn't personally meet my co-panelists, so that was unusual as well. So the process, I should also say that they were extraordinary people, not just eminent experts in their field, but it's so collegiate and so professional and so willing to work with me, coming in late to the whole situation. I remember the day the exhibits arrived from Korea via Fed Express at the front door, and it was a pile about 3 feet high, and I had to just get on top of all of that so quickly. So look, we for some reason hit it off, and we were able to deal with a whole range of issues very amicably and efficiently, and prepare the report. So I can genuinely say it was not difficult to reach agreement on all of the matters. And where some of us may have had less understanding of something, another person was able to, you know, step in. And I think we were very happy that the report reflected our views. And we did that work in a relatively short period of time. So it was 9 months, I think, from when I started to the report being submitted, which even academically is a lot of work in that period of time, not to mention that all of the panel were doing their day jobs as well. So it's quite an intense experience.
Thank you.
Great. And I see, Greg, you've got your hand up. Would you like to ask Jill a question?
Thanks very much, Dominique. And can you hear me okay, wherever you are in the world?
Certainly.
And thank you, Jill, for a very interesting and important narrative about these matters. My question, please, for you to perhaps discuss a little is about the ILO's roles in these sorts of matters, either implicitly or explicitly, perhaps behind the scenes or involved in your deliberations, please, if you might reflect on the ILO's role. And I'm thinking of a recent discussion that involved Guy Ryder, when someone put to him that the ILO is a lovely dog, but and the ILO barks, but it really is a dog with no teeth kind of thing, or very few teeth. And just my last comment really goes back to your reflection on the changing American approaches. And I guess initial indications might be that the Biden approach is going to be more like the Obama approach, and even perhaps more pro-labor than Obama, rather than the Trump or the Bush style regimes. But that's merely a comment. Thanks again, Jill.
Well, thank you. As far as I'm aware, and certainly in relation to my part of the panel, I had no dealings with the ILO whatsoever. So that's at any kind of back channel communication, none whatsoever. And I think the it was very important for the panel not just to be seen to be, but to be independent. And we bent over backwards to make sure that we only dealt with the evidence that we've been provided with in the process. So, for example, Korea has been brought before the ILO Committee on Freedom of Association on numerous occasions for breach of freedom of association. So remember I said that even if you haven't ratified the conventions on freedom of association, the ILO's supervisory system will hold you to account if someone complains. So Korean unions had complained to the ILO about Korea, and those matters had to be dealt with. We made sure, and we made a point of it, that we did not have regard to those cases. So we didn't use any evidence that had been brought to the ILO, because it was our view we were interpreting the free trade agreement and dealing with the evidence we'd been given. That was the best way for us to deal with the matter. So you're absolutely right to say the ILO lacks enforcement in the way that a state could enforce something, for example, but it's got this highly sophisticated supervisory system which does generate these principles. So the question for us was, are they sufficiently authoritative? So I suppose we came to the conclusion, based I think on some pretty solid evidence, that they were sufficiently authoritative. So the ILO may not be state-like in its enforcement, but it is the preeminent organisation in the world in terms of these labour rights, being recognised as such by the WTO, by the United Nations, by many courts around the world. And so it's, I don't think, controversial to say that, and that was our view.
Thank you very much. Good on you.
Yes. Ingrid, I see your hand up.
Thanks, Dominique. And thanks, Jill. I've been kind of waiting to hear you speak about this issue for a while, so it's lovely to find out more about it. I have a couple of questions, but they're all pretty small. One, I was interested in the composition of the panel. So as you mentioned, you were kind of on the list as an international labour expert. So I was just, I guess, hoping you'd briefly mention what the background, I guess, what the expertise of the other panel members was. My second question goes to, and you kind of touched on this in one of your other answers, the taking of evidence and the procedures. And you mentioned just briefly before that it was basically up to you as a panel to decide, but I was wondering what regulated that, and in terms of who can provide evidence and so on. And thirdly, a basic question which I should know but don't, what are the consequences of your panel's decision?
Okay, so the panel members, under the free trade agreement, each party selects from the list a person they want. So the European Union selected a professor from the University of Geneva in Switzerland, Professor Laurence Boisson de Chazorn, who was the most lovely person. And then Korea selected Professor Jae-min Lee, who, and both of them are law professors, international law professors, both terrific people, really, really good to work with. So it was a pleasure to meet them. In terms of the procedures, some of them are set down in the free trade agreement itself in terms of the kind of adversarial process. So which party can speak first and then who replies, and the hearing and the public nature of the hearing and so on. But actually how it would all work was a matter for the panel to determine. And we had regard to other, I guess, international arbitration generally. But in the end, COVID sort of put an axe through the whole thing. So we had to have the hearing online, you know, whether we liked it or not. The question of evidence, I think, is bigger than me and this hearing. It's a big issue in arbitration proceedings generally. But I think it's important in labour matters, isn't it? Because you're wanting to hear from the person who was beaten up in the back alley because of their beliefs or whatever. You know, there's the panel received quite a range of emails from individuals in Korea making complaints about various things. As well as from the international labour movement and so on. But it's very undeveloped in the area how these things are to be dealt with. Even the standard of proof is not, it seems to be a slightly open question. So yeah, that became a big issue in the Central American dispute, because a lot of evidence was brought, but some of it was rejected by the panel for various reasons. So I think in future, this is something parties to an agreement might wish to deal with if they want genuine consideration of disputes, which is probably a big if.
Great. I think that they were the 3 questions. Yep. If I can hand over to Trung, I know she's got some questions as well for you, Jill.
Hello everyone, thank you for sharing a lot of information, and I read the report of the committee, and I find I have some questions. The first one is like the EU-Korea FTA require the losing party to make their best efforts to accommodate advice or recommendations, whereas in the Korean and US FTA, it allows the success complaining party to impose trade sanctions or demand like monetary fine to the violation. So do you think this like maybe soft approach remedy of the EU and Korea FTA like good enough to enhance the labor standard in Korea? And given they have like many complaints by civil society to the ILO already, but still the situation in Korea is not I don't know if make much better.
Yeah, thank you. And in fact, Ingrid, you asked me that and I forgot to answer as well. So yes,
sorry, and I have another question.
Can I answer that one first, and I'll come
sure.
back to you while I remember. So the Sustainable Development chapter in the EU-Korea Free Trade Agreement has its own provisions relating to enforcement and sanctions. So it says the parties must make their best efforts to accommodate the recommendations of the panel, best efforts. So actually then the matter goes back into these state-to-state consultation processes. Since the panel's decision, and this is ironic, so remember we found in favour of Korea on the ratification question. Korea has ratified 3 of the core ILO conventions, and we found for the European Union in relation to the 3 TULRA matters, the TULRA has been amended by Korea, but not sufficiently broadly to fully reflect our decision. So that's what has happened. And you're absolutely right, questioner, that under the EU-Korea Free Trade Agreement, if any other provision outside that chapter is breached, there are mandatory arbitration proceedings, and the findings of those matters are binding on the parties. So it's the EU's approach has been to keep the labour provisions out of this mandatory enforcement mode. Whether that remains the case, I'll be very interested to see. So I wonder if the EU might not sharpen its approach. I don't know, but I agree with you that it is more can be done to bring countries into compliance.
Thank you.
Sorry, your second question?
My second question is like maybe given the kind of success of EU in the labor dispute case with Korea, so what are the implications for other trade partners of the EU in the future in implementing the core labor standard, particularly in Vietnam, where freedom of association is like underdeveloped and it recognized partly in our labor code, but like we're still waiting to like guiding regulation in the future. We don't know what will be done.
Yeah, it'll be really interesting to see, and the agreements reached between the EU and China reflect some of the language in the EU-Korea Free Trade Agreement. So I will follow those matters with great interest. It's the free trade agreement labour clauses are so rarely litigated that there's not a great body of case law to refer to, and nor is there a requirement to adhere to previous decisions. So I think people, if a panel is formed in relation to Vietnam, the panel will have to determine the matter based on the language in that agreement and the facts before them. And we'll see what emerges.
Yeah, thank you. I think your case kind of create a precedent to maybe the later case. Sorry.
Hello, baby.
Great, thank you. Thank you for all those questions, everyone. It's been a really, really interesting discussion, and to hear Jill's insights has been a wonderful, wonderful event. We are almost out of time, so it's my job to thank Jill and Nicola for that really informative discussion, and to thank everyone for attending and for participating. It's been great to see everyone. And I also just wanted to thank Holly, who's there behind the scenes from our events team and has helped us set us all up and do all these things. And we look forward to seeing you at the next session by one of our research groups. So thanks, everyone.
Thank you.